Anytime we have a problem, anytime any of our people in our group have a problem, or the people who follow us around the country have a problem with government, with corporate America, with some type of agency of government, whatever it may be, bankers included, the first thing we do, the very initial thing we do, is to notify our opponent in writing of our grievances, okay? And we do this by means of a presumptive letter. Now, we call it internally a presumptive letter. Externally, beyond the group, we never refer to it as a presumptive letter. It is simply a letter that notifies our opponents of our complaints, charges, claims, what have you. The presumptive letter is very unique. Nothing like this has ever been devised before. There are variations of it that people have tried to copy over the years, but I've been doing this for 58 years now. And the way that we structured the letter in the very beginning is pretty lawful, pretty legal. It has two presumptive paragraphs, one in the very beginning, one at the very end. So there's no confusion as to what we mean when we write this letter. There's no confusion about our intent, our objective, and our charges and claims made in that letter. The first paragraph contains quite a bit of information that is rather unique in the annals of law, because what we're doing is notifying our opponent that he has an obligation to respond to our claims and grievances. And we basically say this is lawful notification to you and requires your rebuttal if you disagree with any of the charges, claims made in this letter. You are required to respond in writing after you have received this, but within 30 days of your receipt. And if you fail to do so, then you admit to and agree with all charges and claims we make in this letter, fully binding upon you in any court without your protest, objection, or that of those who represent you, meaning that entity's attorneys. Now, this is very unique language. Words have meaning. They have meaning in the law, they have meaning in court. So what we're saying to our opponent is, number one, if you disagree with anything, then rebut it. Number two, if you don't rebut it, then you admit to it. And number three, you admit to it fully binding upon you in any court. Number four, without your protest, objection, or that of those who represent you. Now, the presumptive letter is what we call an honorable way to resolve any issue before that issue goes further, meaning to any administrative hearing, to any board, to any court, to any grievance committee, etc. When we write the presumptive letter, again, it's an honorable way to resolve a matter before we go further. In that letter, we deal only in truth, fact, law, and evidence. If we cannot support a statement in truth, fact, law, and evidence, or a charge or a claim, whatever you choose to call it, in truth, fact, law, and evidence, we do not make that claim, period. It's a truthful way to resolve an issue. So if you're going to deal in truth, you have to deal in truth from the very beginning. You don't delete from the truth and you don't add to the truth. You keep it as exactly as it is, exactly as it happened. Don't invent stories, don't make claims you can't support. Now, since we're based in truth, fact, law, and evidence, and since we're dealing specifically on some type of unlawful, unconstitutional, or illegal action that our opponent committed, then the charges and claims we make are specific to those actions, to those unlawful, unconstitutional, illegal actions. And again, we don't delete from or add to. We keep it as exactly as it happened. We get into the who, how, what, where, when, and why. It's strictly, directly to the point as we can possibly be. A presumptive letter is not a book. It should be no more, if you can help it, no more than a page and a half or 2 pages. If you can make it less than that, you're in better shape. The principle here is, again, and I'm going to say it over and over, we're based in truth, fact, law, and evidence. We stand on the truth, we stand on the facts, we stand on the law, we stand on the evidence. We can support everything we claim in that letter. Since we're so based, the question becomes this: can our opponent, who is an officer of the law, who's taken an oath to the Constitution, or who may be some type of corporate executive, and as I said yesterday, corporate executives indirectly have an obligation to the Constitution because their corporations are creatures of the state. They were created by the state, licensed to do business by the state. Therefore, indirectly, they have constitutional obligations. So when an entity like that receives this type of letter, based in this type of language, if he has any brains at all, he's not going to respond, okay? Why? He can't. How can he possibly respond to and rebut claims that we have made that are based in truth, fact, law, and evidence? He cannot do that.
He can do it, but he cannot do it truthfully. That's the hook.
Yes, he could do it, but they don't. They don't do it, okay? And the reason they don't is because they cannot truthfully rebut what we have said and support that rebuttal with truth, fact, law, and evidence. So what do? Well, if they respond at all, they'll respond off point. Remember we spoke about distraction? Your enemy, which is the government, make no bones about it, your enemy is the government of the United States of America, the government of Maui, the government of whatever, I don't care where you are, that's your enemy, okay? Corporate America is your enemy. The bankers are your enemy. Make no mistake about this. You are simply a slave. You're simply a cog in an economic slavery machine that has been going on for a long, long time. That's how the system looks at you. So they are your enemy. And you have to be pretty firm about understanding that. The opponent, again, is going to see what we're talking about, and he's going to say, my God, I've never seen anything like this before. The usual letter that goes to any type of public office or corporation is given, circular file treatment, meaning the wastebasket, okay? It's discarded pretty quickly. But when a letter comes in like this is of a different ilk, a different type of letter, a different character, different position. And it invokes liability within the mind of the reader. So again, he cannot respond truthfully and rebut our charges based on truth, fact, law, and evidence. So if he responds at all, he will respond with distraction. And the usual distraction is to take you off point immediately. You're talking apples, he's going to answer kangaroos. He's going to respond in some other type of language, unspecific to your point. And then the other type of distraction is for him to invent charges and attribute those charges to you as if you made them, then argue against those charges you never made. And this is what they do all the time in every court of the country, including the Supreme Court of the United States of America. This is the favorite ploy. This is Law School 101. Never address the issue. Distract, distract, distract. Take that idiot off the point. When you take him off the point, he's an idiot, he won't know where to go.
It's not just law school or courts, it happens everywhere.
Everywhere.
Corporately, locally, administratively, it's just the way they do things.
And that's how they look at you folks. I hate to say it, but that's how the system looks at you. That's how the courts look at you. That's how lawyers look at you. You're idiots, all right? If you're dealing with the law, if you're dealing in court, you're incompetent. If you hire an attorney, you're incompetent. So they're going to treat you as an incompetent. We have to be a lot smarter than that. When we get no response to our presumptive letter, or we get a response, but it's not specific to the charge, we give them the full 30 days to respond. But again, if no response comes after 30 days, we'll wait another 10 days. We're always giving kind of a second chance to anyone to make a resurrection or remand. And if that doesn't happen, about 40 days after the time limit has expired, we'll write an affidavit, which is step 2 in our process. The affidavit basically contains 3 positions. Number 1, Mr. So-and-so, on such and such a date, I sent you a letter notifying you of my grievances in which I made claims and charges against you. That letter specified that you were required to rebut everything in that letter with which you disagree. And it gave you fair warning as to what would happen if you did not rebut. Number 2, some of the charges to which you admit pursuant to the lawful notification contained in that letter include but are not limited to the following. If we've made, let's say, 15 charges against our opponent in the presumptive letter, we reiterate maybe a third of those, about 5, in this affidavit. Now, when we use the phrase including but not limited to, that means that the charges that we specify in the affidavit are not the only charges with which we're dealing. In legal parlance, you never use the word including and then specify what you're including, because that inclusion limits you to what you state. So we always state including but not limited to the following. Number 3, since we're always trying to resolve the issue, because the whole idea here is to resolve the issue now before it goes further, before it goes to some type of tribunal or court system, we always give our folks a second chance. So in position number 3, we will say, if you choose to disagree, or if you choose to rebut anything contained in this affidavit, then do so by means of your own sworn and notarized affidavit, supporting your rebuttal with truth, fact, law, and evidence, with your notarized affidavit sworn under the pains of penalty of perjury of the laws of the United States of America and Hawaii, Minnesota, Massachusetts, wherever we are. In 58 years of doing this, I don't know how many tens of thousands of affidavits have been done. Not only mine, but many, many others who followed our work. Not one rebuttal in 58 years. And we go back to the central position. Why? I mean, you know, lawyers represent corporations who graduated from Harvard Law School, Yale Law School, Princeton, some of the best law schools in the world. You're dealing with some of the top corporate executives in the world. Why would they not rebut our affidavit with their own? They can't. How in God's name is anyone going to rebut our affidavit and support their rebuttal with truth, fact, law, and evidence when the charges we made are based in truth, fact, law, and evidence, and it's impossible to rebut them? So they don't. They simply do not rebut that position. As usual, we give 30 days to rebut. Once the 30 days are up, we'll wait another 10 days or so. If no rebuttal comes, then we will take the affidavit, and this is very important because we're always building our case and making our case with every step in our progression, so that when we get to the final position, our opponent really has nothing and we have, you know, if you will, all the aces. We're holding all the cards, we're holding all the high hands, our opponent really has nothing. We will record the affidavit and sometimes the presumptive letter, but it's really not necessary to record the presumptive letter. You can if you wish. But the most important is to record the affidavit on the public record, not with the court, because court hasn't commenced yet, but on the public record with your local county. And you do that with your county clerk recorder. Here in Hawaii, it's called the Bureau of Conveyance. Most of these organizations have what they call miscellaneous files. So if we want to record a public document with the county, the clerk may say, where do you want to record it? We will say, anywhere that's convenient with you, and if you have a miscellaneous file, that's fine. So when we record that document on the public record, we do so because we're invoking certain federal and state rules of evidence. Rules of evidence are very important when you go to court. Some of the rules we invoke federally and locally are 201, 902, and 301, by which your affidavit is considered self-authenticating because it's never been rebutted, therefore stands as truth before the court and can no longer be rebutted. The time for rebuttal is over. When we go to court, when anyone goes to court, the only reason people go to court, entities go to court, is because there's a controversy amongst or between parties. One party is the defendant, one party is the plaintiff. There's some type of controversy. Well, if we go to court and our affidavit is considered truth before the court and it's self-authenticating, it stands on its own, and it is unrebuttable at that point, in that affidavit, we have stated the position that our opponent admits to all of our charges, all of them, without exception. By the opponent's failure to rebut with his own affidavit, he's accepted that premise. He's accepted the fact that he's admitting to all of our claims and charges. Well, if that's the case, where's the controversy for the court to hear? There is none. So this is why we do these types of things, these types of methods. We build the case before we ever get there. Now, when we do the recording, we will make a copy of the face of that recording and send it to our opponent just as a notification, just as a notice, so he realizes that we're loaded for bear and we're ready to go ahead to court if absolutely necessary. If we hear nothing from our opponent and we're defendants in the action, we wait for our opponent to make the next move. It's up to him whether he's going to pursue this further or whether he's not going to pursue this further. If we're plaintiffs in the action, we'll wait a certain amount of time, usually 30 days, and if we receive no further notification from the opponent, then we will send a formal notice of suit to our opponent. And that's our last constitutional / administrative or vice versa approach to resolve the issue. If the opponent doesn't budge at that point, then we put our complaint together, we file suit, and we move ahead. Over the long run, about 80% of these issues have been resolved before we have to go further. When we go to court, we win the other 20%. In the time in which Margy and I were active in New Mexico, which was a little over 10 years, we resolved about a little over 75% of the issues by and through the affidavit. So roughly between 3 out of 4 times or 4 out of 5 times, if you do the process pretty streamlined as we have done it, you have an excellent chance of resolving your issues. When we have to go to court, when we're forced to go to court, it depends upon whether we're in criminal action or civil action. Let's talk about criminal action first. Let's say we're defendants in a criminal action, or our people are defendants in a criminal action. There are rules of criminal procedure. Federal rules of criminal procedure, federal rules of civil procedure, state rules of civil and criminal procedure. You really have to know the rules. If you're going to be playing football in the Super Bowl, you play by NFL rules, not by the rules of tiddlywinks, because that's not going to help you in the game. When you go to court, the game is played pursuant to their rules. You may have all the constitutional positions in the world to support you, but if you don't abide by the rules, the court can throw out your constitutional positions. So you must understand the rules of the court. In the local rules here in Hawaii, as in local rules everywhere regarding criminal procedures, the prosecuting attorney is required to do certain things. When the arrest is made, if an arrest is made, the system is required to do certain things. And all of these procedures are spelled out in the rules. Usually when an arrest is made, the one who is arrested has to be read his Miranda rights. Very rarely does that ever happen, rarely. And you can move to dismiss on that because Miranda is a major case. And if one has not read his Miranda rights and realizes that he can move to dismiss on that basis alone, he can remove the action from his plate rather quickly. Most people know nothing about Miranda, therefore they don't use them.
And there's also another caveat here. Recently, some of the people that we dealt with in Oahu said that during a police stop that took place for some reason, they were told, one of them said, "You didn't read me my rights." And the police officer said, "I don't have to read you your rights unless I'm going to interrogate you." And I said to the fellow, "Did he ask you any questions in the process of this stop?" He said, "Yes, he did." I said, "Isn't that an interrogation?" He's like, "Yeah." I said, "Well, the next time, if this ever happens to you again and a policeman makes that statement, say, you're already interrogating me and you haven't read me my rights. Okay, you're going to nullify this whole action." Because they are looking for ways to circumvent reading people, and they're not Miranda rights per se. The rights read to you pursuant to the case Miranda versus Arizona, which is a landmark case because a fellow who was actually a serious criminal and a murderer had to be let go because the police didn't apprise him of his rights to remain silent before they started questioning him. That's why this is a big case. And the police are looking at ways of circumventing that, so you have to be aware of that and don't fall for that baloney.
Usually there's a procedure that requires the one who's arrested to be brought before a magistrate within a certain period of time. That rarely ever happens also, okay? So again, we have to know the rules. We have to know under what system we're dealing. And if we don't know the rules of that system, we don't know our rights. And as we've said many, many times before, in America, if one does not know, demand, claim, and exercise his rights, he doesn't have any. So when people are arrested, they really have to know the rules. Now, one of the rules comes under Rule 2, Federal Rules of Criminal Procedure, and requires the prosecuting attorney to essentially verify the charges by means of his own oath. In the vast majority of situations, this never happens. So there, the attorney, prosecuting attorney, is not following the rules as dictated by the procedures. When we go to court, the first position in the court is arraignment. In a criminal procedure, the first position is arraignment. If you know what you're doing and you exercise your constitutional rights and demands, as we do, as our people do, the possibility of winning the case by getting a dismissal, and a dismissal, believe me, in this system is a win, is pretty good if you know the procedures to use in arraignments and arguments and challenges that you use in arraignments. We have been to court many, many times. We don't like to go to court. As many times as we've been there, we don't like it. The court is a very corrupt system. Judges are very corrupt. Lawyers are very corrupt. Even your own lawyer is corrupt. I don't care how well you know him. The guy's corrupt. I mean, the guy is essentially a whore. I hate to put it that way, but that's what he is. He has sold out his integrity to the system. He doesn't represent you. He may be a nice guy, and in some cases, he could represent you, and he could actually win a victory for you. And there are some lawyers like that, and they're the exception. I'm talking about the society of lawyers. They are prostitutes of the highest order, highest order.
Or lowest, as the case may be.
And they work within, yes. And they work within an extremely corrupt, evil system that is using you as money pegs. That's all it is. The best thing to do, as far as we're concerned, is to speak for oneself, and that's what we teach people, to use the Constitution to speak for themselves. Now, we don't give any legal advice, as you know. We don't give any lawful advice. We just tell people what we would do if we were in their particular situations. And everything we're discussing here are things that we've done in the past and our people have done in the past. When we go to arraignment, the first thing the judge wants to do is to get you to enter a plea right away. Second thing he wants to do usually is for you to strike some type of plea bargain, serve 30 days, 90 days, 2 years, whatever it is, or get you to pay money. Either way, the system makes money. Why? Well, if you cough up money, the system is making money from you. If you go to jail, the system is making money from you. Why? Jails are privatized. It's one of the highest profit items in this nation. We have a population in this world of roughly 7 billion people, maybe a little more than that. We have a population in this country of roughly 315 million, give or take. The United States of America, taking those percentages in mind, the United States of America has an incarceration program by which 26% plus of the world's population
Of prisoners.
is
26%?
Of the
Plus.
world population of
plus
prisoners
is
in
incarcerated
this country.
in American prisons. So get those figures, 315 million plus or minus in America population, world population of 7 billion, okay? Overwhelming percentage in favor of the rest of the world. Yet this country has 26% plus of the world's prison population right here.
And a footnote to
Big
that,
business.
those people in prison, the vast majority of them
Are
are
innocent.
not what you would call criminals. Some of them are guilty perhaps of crimes against themselves because they got involved in drug usage, but they're not criminal in the normal sense of the word. And many of them accused of so-called criminal charges are innocent. They've been railroaded. It's really horrendous what's going on. And it's a great way to disenfranchise a lot of people, take them out of the realm of productivity, off the voting rolls, etc. It's really scandalous.
So in the arraignment, that's the position of the judge, that's the position of the system. They want to nail you and they want to nail you fast.
Big time.
First thing the judge will say is, usually to the prosecutor, is the city, is the state ready to proceed? Yes, Your Honor, city's ready to proceed. Mr. So-and-so, are you ready to proceed? They usually say yes. You never say yes. You never answer questions in court. You challenge the question, okay? But people will say yes. And then he'll say, how do you plead? And the guy will say, not guilty, guilty, whatever it is. Well, when that happens with us, we make a little rhyme out of it. We say, we make no plea because this court has no jurisdiction over me. And the judge will look at you and say, what are you talking about? Of course I have jurisdiction. This court has no jurisdiction over me. Sir, it's never Your Honor, it's always sir. No titles of nobility in America. And as a matter of fact, I have filed a challenge of jurisdiction with this court, which we always do. That's the first order of business. We file a challenge of jurisdiction with this court. And in that challenge of jurisdiction, we demand that the prosecuting attorney, whoever he is, certify on the public record that this court has proper jurisdiction. That's a judicial and legal and lawful impossibility, because the only court that Americans are constitutionally ordained to be tried in are constitutionally dedicated Article III courts.
Judicial
There are no,
in nature. Yeah.
yes, there are no Article III courts in existence in this nation, including the Supreme Court of the United States of America. They're all fraud, they're all corporate, they all operate either under Article I legislative courts, as we said yesterday, or Article IV territorial courts. How can one have a legislative court that is judicial in nature? It's an impossibility. How can one have a territorial court that's judicial in nature? And another impossibility. How can one have a corporate court that's judicial in nature? Another judicial impossibility. Because these courts serve their own interests and their own systems. They don't serve the Constitution. They don't serve the rights of the people. So in our demand, in which we require that the opponent's attorney certify on the public record that this is an Article III court, he cannot do so. So he doesn't, all right? And we will say, we have filed this document, this challenge document with the court that requires the opposing attorney to certify that this court is a proper Article III court, constitutionally ordained as such, not constitutionally defective, and prove this on the public record. He has failed to do so. Therefore, this court has not evidenced any proof of jurisdiction by and through the prosecuting attorney. Therefore, we move for immediate dismissal of all charges with prejudice for lack of jurisdiction. That's what we do on arraignment. There are other things we do on arraignment as well. We can combine the other two positions. First of all, as I referred to before, under the Federal Rules of Criminal Procedure, Rule 2, or in some cases, in some states, Rule 3, the prosecuting attorney is required to certify the charges as valid by his own oath. They don't do this. And if they do this, they never produce this documentation. So we could move to dismiss verbally on this basis as well. In other words, when we move to dismiss, it's best to have as many positions for that motion as possible. Jurisdiction is a valid position. When you combine the fact that the prosecuting attorney has not certified the charges by his own oath, then the charges are bogus and fraudulent. The court has no authority to hear and adjudicate those charges. The attorney has no authority to even file those charges with the court. So we can combine these two positions in that matter. Number 3, in a criminal trial or a criminal procedure, whatever it is, we are entitled to face our accuser. We are entitled to confront our accuser.
And witnesses against us.
Yes, and witnesses against us in all proceedings. Well, since the first proceeding is the arraignment, and in the vast majority of arraignments, I mean virtually all arraignments that take place, your accuser is not there. The only one who is there is the prosecuting attorney. Since we have the right to face our accuser and to confront our accuser, and he's not there, we can move for dismissal on that Sixth Amendment position. There's a fourth position, but we don't even need it. The attorney cannot testify. The attorney cannot testify as to exactly what happened. In the arraignment, charges are made against us, but the attorney, the DA, the AG, whoever he is, was not present when this action took place. Therefore, he cannot verify the charges, which is why he's required by Rule 2 to verify them pursuant to oath. So in all of these positions, we can move for dismissal. We have to know our rights, and if we don't know our rights, the system will take us over the coals. Now let's get into a civil situation. Civil is essentially same procedure as criminal, but there's a little different position, there's a little different effect here. In the civil matter, let's say we're defendants. Someone has made charges against us in a complaint. That's the first order of business. Well, we're required to answer that complaint, which we always do. We rebut the charges with specificity in our answer, and then we usually file a challenge of jurisdiction, and we file a motion to dismiss. Now you got to remember, when you file anything with the court, any motion, any challenge, any document, since we're challenging the jurisdiction of the court, and you'll see this in our documents, we, in the document that we file with the court, state that we are filing this document by special appearance and do not accept the jurisdiction of the court. By special appearance, we do not accept the jurisdiction of the court, because once you accept the jurisdiction of the court, which you would do by filing a document without that condition, then the challenge simply goes away. So please keep that in mind anytime you file anything with the court. In a civil situation, charges and claims are made against us. We respond to it as stated. The first order of business is usually a preliminary hearing, okay? Usually a preliminary hearing. During the preliminary hearing, the intent of the judge is to get this case off his caseload. He doesn't want to hear the case. He wants to lighten his load. So the idea is try to resolve it one way or another dismiss it one way or another and just get it off his desk. So when the court convenes, the judge usually will look at the opposing attorney and say, Mr. So-and-so, the plaintiff's attorney, are you prepared to proceed? And he'll say, yes, Your Honor, the prosecutor, we are
Plaintiff's
prepared.
ready to proceed.
We are prepared to proceed. Then he'll look at us, Mr. Flynn, Mrs. Flynn, whoever is representing our position or speaking for our position. Are you prepared to proceed? Now, this is your opportunity to turn that court into a constitutional Article 3 court if you so choose, because that's what we do. We'll say, no, sir, there are several matters we must clarify before we go further. In our cases, the judge always says, go right ahead. Right away, we engage his eyes. You look right into his eyes. You bore a hole right in his head. And we say, sir, you and the opposing counsel have sworn oaths to defend and support the Constitution of the United States of America and the Constitution of whatever state. Then we pause just for a second. Is that correct? Now, as I said yesterday, we don't ask questions in court unless we know the answer. We don't ask them. We ask leading questions that will give us the answer we want. This is a trick of the trade. If you really want to learn how to proceed in court, you have to learn that position very well. In this situation, we've made a statement that's based on truth, fact, law, and evidence. We know that the judge is required to take an oath. We know the attorney is required to take an oath. It's required by the federal constitution, the state constitution, federal law, state law, and usually county law. So there's enough precedent to demonstrate that these guys that we're facing are required to take that oath. So we make the statement, we ask the confirming question, is that correct? The confirming question goes exactly to the statement and nothing else. We always get a yes. Then we follow that up right away and say, with all due respect, you and the prosecuting attorney are required to abide by those oaths and the performance of your official duties before this honorable court. Is that correct? When we get a yes answer to that, this is on the public record because this is supposed to be a court of record. We have commitments by the judge, the presiding judge in this trial, that both he and the opposing attorney have not only taken oaths, but are required to abide by the mandates of those oaths and the performance of their official duties during this trial. You have unofficially, or we have unofficially, because we're talking about what we do, we have unofficially converted that court from the corporate, phony criminal court that it operates as into an Article 3 court. Now, the judge is not happy at all. The prosecuting attorney is absolutely livid because the judge is answering for the prosecuting attorney or the opposing attorney in a civil matter. He doesn't like that because he doesn't like to be bound by his oath. And he doesn't like to be bound by the constitutional mandates contained in their oaths. I'll give you one example here. Helen and her family flew over from Southern California to attend the seminar. And in a matter that's ongoing, a criminal matter against them, which is totally unjustified, they used some of our procedures, and through these procedures and through the demanding of their constitutional rights, had two of the attorneys that were assigned to them, public attorneys, fired. They're no longer operating. Now, we can do that if we so choose, but most people don't choose. Most people just go along with the game.
Because
they go along with the program.
They don't know. Be clear on that. We know that no one wants to put himself in harm's way. There's no deliberate intent to just be a patsy. But because of the lack of information and knowledge, which is deliberate on the part of the system, people stand up and allow themselves to be slaughtered in court because they don't know how to advocate for their own rights. And that to us is tragic, it's unnecessary, it's unfair, and that's why we try to awaken people to their rights so that when they do have to go to court for any reason, they're not going to be treated like, cattle.
Exactly, exactly. When we have established those positions, and when we get yes answers, again, I repeat, unofficially, we have converted that court into an Article III court, which is the only court constitutionally ordained for the American citizen. However, there's a caveat to this. You can't do this unless you know what you're doing. I used to be a pretty good boxer. I used to be a pretty good quarterback. But if I try to go on the field, February 5th and play quarterback for the Patriots, I'd be lucky if I lasted 4 plays, and I would totally screw up the team because I'm not qualified to play in that arena. Maybe one time I was, not now. Same in the ring. I'm not going to hop in the ring with a heavyweight champ of the world. I'm not qualified to do so. So you have to be qualified to do what you think you can do. And it's not a question of thinking you can do it, it's a question of knowing you can do it. So once you have qualified the judges, or the judge, for both himself and the attorney, the prosecuting attorney or civil attorney, then you must hold that judge and that attorney, as we do, to the constitutional mandates contained within their oaths. And you must know exactly your rights, you must know all aspects of due process of law, and you must know only the duties that these guys must abide by. In other words,
The limitations.
they only have certain requirements and latitudes within court. You must know fully the scope of those latitudes, fully. They have limitations imposed upon them. They have limited delegated authority. You must fully understand what that is, so that when one of these guys goes out of his limited delegated authority, you call him on it, you call him on it immediately. You must fully understand all aspects of constitutional rights, and you must fully understand all aspects of due process of law, including not only constitutional due process, but administrative due process and procedural due process. Because if you do not know this, they will hand you your backside very quickly. Because although the judge says, yes, I'll abide by my oath, yes, that's correct, Mr. Flynn, you're right, I will abide by my oath in the performance of my official duties, etc., etc. Within 30 seconds to 1 minute, he will test you. And if you flunk the test, you've lost your position, you've lost your advantage. So you must know what you're doing. Secondarily, right after we say this, or let me come back to this position. Some judges may not want to answer this. Some judges would be loath to answer this. We have never found a judge who says no. Any judge who says no commits immediate treason and can be immediately disqualified. Just as we discussed on the NDAA vote, the congressmen and the senators who voted for that committed treason, and that treason is on the public record. It's recorded by their vote. Well, if a judge were to ever say, no, I don't have an oath, or no, I'm not going to abide by my oath, then that judge on the public record commits treason.
They're not that stupid.
No, they're not. I've never seen any judge say no. And if he does, he's a real idiot. And if he does, you have to remove him very quickly. But what they may say is, I'm not here to answer any questions, or what does this have to do with anything, or I don't want to hear this nonsense, okay, or move on. Again, distraction. Distraction, 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 taking you off your point. Stay on your point. Say, sir, I have made a statement that is based in fact and law. You are required to take an oath. You are required to abide by that oath. Are you saying now in the public record that you either do not have an oath or will not abide by your oath? Just like that. Wait for his answer. Now there are some other things you could say as well. There are a variety of things you could say, but keep it simple, keep it limited. You could also say, sir, I've made a valid statement and you know that you're required to have an oath. would you like to reconsider the question and answer the question? If he refuses to answer the question, then you could say, sir, by your response, it appears that either you have not taken an oath, or you have taken an oath, but have no intention of abiding by that oath in the performance of your official duties. I am guaranteed due process of law during these proceedings. If you haven't taken an oath or will not abide by your oath, it's evident that this court will not provide me due process of law, and any court that acts absent due process of law forfeits any jurisdiction. Therefore, sir, you are either disqualified, or if you admit that this court lacks jurisdiction, the only ruling this court can render is a dismissal.
With
Okay.
prejudice.
Don't play their game, play your own game, all right, and put it right back on them. Remember, you don't want to get into the merits of the matter. You do not want to argue this position in court. You want to win on challenges. If you're a defendant, you want the case dismissed. If you're a plaintiff, you want to win on summary judgment right away. So these are positions that you must understand, and we would suggest that you read over the handouts if you're really interested in trying to advocate for your rights and trying to protect not only your rights but those of your family, and hopefully those of your communities, and hopefully start a movement, as late as it may be, to reinstitute constitutional governance in this nation. Now is a good time to start. It's never too late. Doesn't matter how bad it looks, there's always hope. And as long as hope is based in belief that it can be done, then we can take the first step and move forward. Now, getting back to our procedure. After we've exercised 1A and 1B, which I just discussed, which is on the constitutional court challenges, we inform the court of exactly who and what we are and how we appear before the court. So we will say, I appear before this court as a living, breathing, flesh and blood, natural-born, sovereign American citizen, with and claiming all rights guaranteed to me in the Constitution of the United States of America and the Hawaiian Constitution, with my name lawfully and properly spelled in upper and lower case letters. Then we pause a few seconds and we ask the question, is there any objection to what I just stated? Who in God's name can object to that? No one. No one can lawfully object to that. Someone might try, but there's no lawful position for the objection. First of all, the judge cannot object. What is the judge? The judge is the arbitrator. He's the middleman. He's there to see that the court performs properly and proper decorum and proper law is upheld in the court. That's officially what he's there for. Unofficially, he's there to screw you right into the ground. Unofficially, he's there to hurt the citizen and help anyone who opposes a citizen. I mean, if it were Attila the Hun, who just raped and pillaged and killed 60 nuns up here, is opposing the citizen in court, the judge is going to favor Attila the Hun. That's just how it is. The system is evil beyond measure. And you have to know that, and you have to know how to be able to win in it if you want to win and if you want to follow our methods. Once we make that statement, the only one who can lawfully object to that statement is our opposing attorney, whether it be a prosecutor in a criminal case or a civil attorney in a civil case. He's the only one who can properly object. If he does not object, then what we have just done is provide judicial notice to the court regarding our status before that court and how we appear before that court. Again, we appear as a flesh and blood, living, breathing American citizen. We're not a corporation. If any confusion exists as to who and what we are not a corporation, because you are considered corporations. You are considered 14th Amendment citizens. You are considered U.S. citizens. You are only to be extended privileges at the discretion of government. That's how government looks upon you. They don't look upon you as sovereign American citizens imbued with entitled to full constitutional rights. Can anyone say that we're not sovereign citizens? No, the government is trying to claim that, but in court, the court cannot claim that. Can anyone say that we are not entitled to our lawful constitutional rights? No judge is ever going to claim that. No lawyer should ever claim that. And when we talk about our name being spelled only in upper and lowercase letters, if there's no objection, then anything about the straw man or any artificial person goes right out the window. So we have noticed the court as to how we appear before the court and who we are before that court. Number 3, if we know the charges that have been filed against us in the complaint are untrue, if we know that they're bogus and fraudulent, which the vast majority of charges in criminal cases are, the vast majority, well over probably 98, 99%, because the government is out there attacking American citizens to make money from them, or put them in jail to make money from them. They don't care whether you're innocent or guilty. Doesn't matter to them. They want your money or they want you to go to jail. So if we know the charges are fraudulent and bogus and have no lawful merit, and we can prove that, whether the matter be civil or criminal, then we would say, well, let me clarify. Remember, in the criminal matter, the prosecuting attorney is required to certify, and it's different for every state, but the essential language is this, the essential concept is this. The prosecuting attorney is required to certify under oath that the charges are valid. In a civil situation, the attorney has a similar requirement, and this comes under Rule 11B of the Federal Rules of Civil Procedure. And under Rule 11B, which changes, because these change quite a bit, the attorney is required to represent that everything he presents to the court is true and correct to the best of his ability. Everything. That means the documentation, that means the oral arguments before the court, that means the charges, because everything is presented to the court. So if we know that the attorney has filed fraudulent, bogus charges against us, and we can prove that, then what we will say right after we make our status statement is, sir, I move to dismiss this case because the charges brought against us are fraudulent and bogus and have no lawful weight or merit. Now, if our opposing attorney, whether it be civil or criminal, has any brains, he will keep his mouth shut. In civil matters, since they're looking for money or they're looking for something else, they're a little more avaricious, so they may object. But the bottom line is, if the attorney has read our paperwork, is familiar with our positions, has been with this case from the very beginning, the attorney realizes that he has no valid position before the court. Lawfully, he cannot win in this court. The only reason he's pursuing the matter is he believes, if he's connected with the government, that he has a corrupt judge who works for that same government, who is going to uphold the position of that government no matter what that government did. That's the deal. You know, we're the insiders, he's the outsider. You know, the judge is going to protect me and I'm going to protect the judge because we work together. That's the only reason he's going to pursue this action. In a civil sense, it's the same way. The corporation believes it's already bought the judge, and in most cases it already has bought the judge, one way or another. Either through a direct bag man, which still goes on, and or through contribution to judges' funds and retirement funds and things of that nature. There are all sorts of ways that these guys get bribed. If the attorney feels as though he's got a strong connection with the judge, or if the attorney feels as though he really wants to get some money from us, he's going to object. And when he objects, then we will respond and say, pursuant to Mr. So-and-so's objection, then I move that Mr. So-and-so certify the charges against us as valid, lawful charges specific to the Constitution of the United States of America, the Constitution of Hawaii, in particular, specific to the Bill of Rights, by means of his own sworn and notarized affidavit, signed under the pains and penalties of perjury of the laws of the United States of America and the laws of Hawaii. I've made a second motion to the court based upon the objection by the attorney. Now, what's the position for the attorney? The attorney realizes that he has put fraud upon the court, he's misrepresented to the court, that he's presented false evidence to the court, that his charges have no lawful weight and no lawful merit. He knows that. He's not stupid. I mean, these guys are dumb, but they're not exactly stupid. They're arrogant. They believe they don't have to do certain things because the courts are so damn corrupt that all we have to do is show up and this fool who thinks he's a citizen or a constitutionalist is going to lose. Well, they get surprised rather quickly. So in this particular situation, we have a motion before the judge. We have two motions before the judge. The attorney objected to the first motion. We have a second verbal motion before the judge based upon that objection. The judge knows, or should know, that the attorney believes in one way or another that the judge is going to automatically rule for the attorney. However, the attorney knows he's put fraud upon the court. He knows that I know this, okay? So they're in a quandary. They've got a bit of a problem here. What are they going to do? Yeah, it gets a little comical because this is all on the public record. Usually in such a situation, there's a conference. And we don't have to do this very often because we win most of our cases, believe it or not, within 5 to 10 minutes and sometimes within 60 seconds. Literally. We win on arraignment right there. It goes no further. Or we win on the initial proceeding, initial hearing, it goes no further. So we don't have to get into these positions very often, but when we do, what happens is this: the judge either immediately dismisses the charges, or dismisses it in a criminal matter, or dismisses the case against us in a civil matter, and or calls a conference. So we'll go up, and the judge will start talking about the latest hockey game or the football game that's coming up this weekend. I mean, I'm exaggerating, but what they do is they'll never be specific to the point. They'll never address the point. They'll never address the issues. And then for some obscure reason that comes out of right field, the case is dismissed because the attorney either withdraws the charges or the judge dismisses the case, and that's the agreement, and it's over. Now, when it's dismissed, it's never dismissed pursuant to our motion, never. But it is dismissed, and we don't care whether it's dismissed pursuant to the motion or not. We just want the damn thing on our end, our victory, our side. So we walk away, we're victorious, and the attorney has his tail between his legs, and he's glowing at us like, I'll kill you, I'll kill you. Who the hell are you? Where'd you come from? You know?
They don't like to be shown up by
No.
people they look at as cattle, you know. It's a little insulting to their egos.
Helen filed some motions and documents with the court, and basically they all dropped their pants. They didn't know what to do. They were caught in a state of confusion. And who knows how it's going to go. Well, she's in Southern California, extremely corrupt system, extremely corrupt AG. You never know how things are going to go, but right now it's turning in her favor. And Hendricks also, her son. So we hope that's the case, and we hope the Constitution prevails in their situation. So that's the procedure from A to Z, whether we're talking criminal or we're talking civil.